grab the quorum. Hopefully someone's coming behind me. You never know. It's like a game show behind me. We'll see who comes through the door. No one, so you can begin.
Mr. Chair, members of the committee, thank you for your time today. For the record, I'm Senator Brad Hudson, representing the 33rd District. This morning I bring you two pieces of legislation that could have a profound impact on the lives of victims of childhood sexual abuse. I will introduce these bills, but I intend to be brief so that you can hear from the witnesses and experts who have joined us today to provide testimony. I'm happy to answer any of your questions, but will also make myself available to any members of the committee that would like to visit with this after the hearing so that we can maximize the opportunity for witnesses to testify today. Senate Bill 1140 is a critical piece of legislation for Missouri's children that eliminates the statute of limitations for civil cases related to childhood sexual abuse. The current statute of limitations in Missouri requires that childhood sexual abuse survivors file their cases by age 31 if against the person who abused them, and by age 26 if the case is against an institution that facilitated their abuse. A rigorous body of evidence shows that survivors of childhood sexual abuse delay disclosure of their abuse on average over 20 years, with many delaying disclosure well into their 50s and 60s. This means that most survivors will never have the option of using the civil justice system to cover the decades of costs they incur for their healing. By assigning an arbitrary statute of limitations for child sexual abuse, we are siding with abusers and perpetrators over survivors and making Missouri a sanctuary state for pedophiles. This must end. Senate Joint Resolution 93 would allow Missouri voters to decide whether to adopt a narrowly tailored constitutional amendment permitting the legislature to pass retrospective laws related to civil claims of childhood sexual abuse. If approved by the citizens of Missouri, this amendment would give the legislature the authority, but not the obligation, to enact a time-limited revival period, allowing survivors to pursue civil claims that would otherwise be barred by the statute of limitations. 31 states have enacted revival laws for childhood sexual abuse, with most providing temporary windows of 2 to 3 years. Missouri currently cannot enact similar legislation due to constitutional limits on retroactive civil laws. This amendment would allow Missouri voters to decide whether their legislature should have that option. This amendment applies only to civil claims seeking accountability and compensation. It does not affect criminal statutes of limitation or criminal prosecutions. Revival periods do not guarantee outcomes. They simply allow courts to evaluate claims based on evidence and existing legal standards. These laws promote accountability, help identify hidden perpetrators and institutional failures, and strengthen protections for future generations. I would like to once again thank the many witnesses who have come to provide testimony, and I'm happy to take any questions from the committee if there are any.
Thank you, Senator. Just for clarification, this is going to be the public hearing on both of these bills, on Senate Bill 1140 and Senate Joint Resolution 93. A lot of the witnesses, rather than having you come up twice for or against, just clarify on your witness form when you come and present your testimony which bills you are for or against. Could be one, could be both. Again, that's Senate Bills 1140 and Senate Joint Resolution 93. Senator, I want to commend you for this hard work on this issue. Digging into a lot of these cases and a lot of the testimony that we'll hear, it's gut-wrenching. Yeah. It's also inspiring that so many victims are coming forward to share their stories and try to seek justice for future generations. I'd like to open it up for any questions for the sponsor. Seeing none, I think you have a list of the witnesses that you would like to come up. We're going to start with witnesses in favor. The first two will get 5 minutes, and we're going to alternate. After your first witness, we'll go to those against these bills. So okay. Who would you like first?
Elizabeth Phillips.
I know you've been here about 3 or 4 years in a row now. You know the drill. If you have a witness form, leave it on the desk and proceed when ready.
Thank you, Chairman Schroer. Thank you, Senator Hudson. We really appreciate you allowing survivors the opportunity to share their stories today. I have been working on statute of limitations reform in Missouri for the last 4 sessions because my brother, Trey Carlock, died as a result of the abuse he endured at Kanakuk Christian Sports Camp based in Branson, Missouri. He was groomed and abused from the age of 7 to 17, and his perpetrator was put away for 3 life terms and is detained here in Jefferson City at Jefferson City Correctional Center. The address for that is 8200 No More Victims Lane, which is why my advocacy organization is called No More Victims. I am here with an army of survivors who deserve the majority of the opportunity to testify, but I'm just going to show some highlights as to why we want to prioritize Senate Joint Resolution 93 this session. There have been statute of limitations reform bills filed in the past, and our opposition gets up here and just says it's unconstitutional. Well, I know that the Missouri Constitution has been changed over 130 times. And so what we are asking for this Senate Joint Resolution 93 is to take this to a vote of Missouri citizens to decide if they want to amend the Constitution very narrowly, Article 1, Section 13, to allow survivors of child sexual abuse and trafficking to have access to Missouri civil courts. We've petitioned this legislature also in the past for extending or eliminating the civil statute of limitations prospectively to match what has been passed since 2018 in criminal law here in Missouri. Because my brother died by suicide in 2019 after enduring the unimaginable and then Kanakuk putting him under an NDA, this legislature passed Trey's Law to prohibit the misuse of NDAs in child sexual abuse and trafficking cases moving forward as of August 28th of last year. And thank you. I'm back here in Missouri from Dallas, Texas, because Missouri still has a pedophile problem. Trey's Law helped with that, and you'll hear from survivors who can finally speak about what happened to them at the hands of Kanakuk today. But until we deal with the civil statute of limitations in this state, it remains, as Senator Hudson said, a sanctuary state for pedophiles. Since 1938, the civil statute of limitations to sue an institution liable for child sexual abuse and trafficking is 26. What we know about delayed disclosure and what research tells us, and you'll hear from the subject matter experts behind me, is that it takes victims on average 20 years to come forward about their abuse. So the arbitrary age of 26, which has been driven down by insurance lobbyists and tort reform lobbyists to keep it in place, I think it's time we change that before we hit the centennial on this arbitrary number being the statute of limitations to sue an institution in Missouri. Currently, you can sue a direct perpetrator up until the age of 31, but as you know, you can't put an institution in jail, and there are other parties involved beyond just the direct perpetrator who are oftentimes liable for a child's abuse. So in favor of both SJR93 as well as SB1140, which would prospectively eliminate the civil statute of limitations so that future victims can have access to the civil courts. It is not retroactive, which is why we need to pass this joint resolution so the legislature in the future can decide if they want to open a statute window like 33 other U.S. states and territories have done in order to tell pedophiles that they are not welcome in this state. I want to end with a verse that drives my work at No More Victims. It's Ephesians 5:11. Don't participate in the fruitless works of darkness, but instead expose them. Today, we are exposing darkness. You're going to hear some hard things, but this work really matters. And I think if Missouri decides that they want to stand with kids, there are a lot of victims who would be very grateful for the opportunity to tell their stories in Missouri's civil courts. Until this legislature takes action, children will continue being harmed. There will be a pass the trash situation ongoing, and we'll continue to have to pursue justice in other state civil courts when perpetrators have been indicted in other jurisdictions. That's what's continuing to happen. So again, thank you, and I'd like to yield to the survivors behind me to testify.
Thank you for your testimony today. Before we open it up to questions, we're going to pause, and Mr. Secretary, can you call the roll?
Senators Schroer.
Here.
Gregory 15. Brown 26.
Here.
Berger. Here. May. Roberts. Schnelting.
Here.
You have a quorum.
Having a quorum, we will begin or continue the public hearings on Senate Joint Resolution 93 and Senate Bill 1140. Elizabeth, I too want to echo what I said to the senator. Thank you for your advocacy. I know losing your brother and hearing from so many victims, it's really hard, and it's heavy stuff that will bring down a lot of people. And you being a survivor yourself, coming through, your family going through all of this horrific stuff that is now being brought to light, I think in large part it's thanks to you, the advocacy of all the people that you're bringing together. So thank you for continuing to fight for this very important issue.
Thank you very much. I'll come back as many years as it takes.
Any questions? Seeing none. We're going to alternate now to the first witness in opposition of Senate Bill 1140 and or Senate Joint Resolution 93. Remember to mark on your witness form which ones you are for or against, and you can even illustrate that in your testimony as well. Begin when ready.
Good morning, Mr. Chairman, and members of the committee. My name is Hampton Williams. I'm with the Missouri Insurance Coalition. I'm here today testifying in opposition to both bills to raise concerns with them. Not to raise concerns with the victims or advocates you're going to hear from today, not in defense of any perpetrator of any sexual abuse, but to raise serious concerns about the structure of the proposals and unintended consequences that they may have. Missouri's criminal laws address the issue of a statute of limitations by making them unlimited. The individuals who commit criminal acts against children need to be held accountable. There's no disagreement on that principle. Our criminal laws are organized 556036 to allow for prosecutions of Class A felonies for any time, 556037 to allow for prosecutions of unlawful sexual offenses can be commenced at any time. The proposals before the committee today address a different legal framework. They address civil liability. And the concern that I'm going to express has to do with effectively turning private lawsuits into a substitute for criminal prosecutions. There's a balance that criminal law has with respect to the protections and procedural protections for defendants. Basically the standard of proof is greater, which affords, I think, this balance for having an extended statute of limitations or an elimination of statute of limitations. The concern with these proposals is not that civil cases should be unavailable, but that removing the temporal limits in civil law changes its character, shifting it from a compensatory framework toward one that resembles criminal adjudication without the structural features designed to ensure accurate and reliable outcomes over long periods of time. This proposal expands liability in two fundamental ways for two different sets of persons. The culprit, the perpetrator, who currently is contemplated in the statute, will have their liability extended prospectively for the duration of their life to an unlimited period of time, and possibly retroactively if the SJR is passed and the legislature takes the additional steps of determined retroactive application of laws. A second, third party will be added to these statutes, who I defined as the non-culprit. That language is found in 3 sections in both proposals. It's defined as an individual whose act by a culprit was caused by a defendant, which is the non-culprit's tortious conduct, and that such conduct causes an act, which is abuse, to occur. In the SJR93, it uses the terminology or contributed to the cause of sexual abuse. In, again, SB1140, it has a terminology, any action against any party to recover damages from tortious conduct that causes a victim to be a victim. The concerns with these language specifically is that they're not defined, they're not bound, and they're not tied to any intent of direct participation of a non-culprit. The consequence is that a non-culprit party is exposed to the same unlimited liability as a perpetrator themselves. And this could be employers, nonprofits, public schools, private schools, churches, youth organizations, landlords, daycares, juvenile correctional facilities, hospitals, possibly even family members. Senator Hudson has been a staunch advocate on this issue. He is a strong voice for the advocate, for those victims, particularly those in his district. And I think that there's a general understanding that for individuals or even institutions that are actively involved in concealing or taking a proactive step in facilitating abuse, that is a different concern than expanding a general liability to all actors or even good actors. The reason that I'm here today is to identify that the insurance markets that exist rate for risks that are known, and that when we have unknown risks, it's going to be nearly impossible for programs such as youth organizations, schools to rate those concerns.
Your time has expired, but I'll
I
give you a
understand.
couple seconds to summarize.
Now, just very shortly, I will also submit to this committee information about the state of California, which imposed similar restrictions, and I should say expanded these limitations. The net effect has been over $6 billion in costs that have been incurred by public school entities. The state of Maryland similarly did something similar. Last year, they actually reduced their statute of limitations, facing, again, $3 billion worth of lawsuits against public entities. The costs are real, and I appreciate the committee's continued conversation on these issues, and I appreciate the time limits as well, and for those behind me.
Thank you again for your testimony today. I want to go back to the middle of your testimony. You said something that I think everybody should hear, and kind of want you to dig further into that. You said how individuals or businesses or entities that are knowingly concealing or shielding some of these predators, that should be treated differently. And you and I have had discussions on this. It's not your testimony today that they should be protected even further, correct? That you think that those individuals and the entities that are shielding predators and continuing to allow them to prey on victims, that we should be amending our laws to deal with them accordingly, correct?
Senator, my testimony is that for those entities that are engaged in criminal activity, they need to be held liable for it. And,
Criminally and or civilly?
I would say criminally. Now, and again, through our criminal statutes, we do have the ability, courts do have the ability to accomplish the assessment of costs. They have that authority. It is possible to do that. But again, the conversations that we've had with either the sponsor of this bill or even with your office identify that when you have parties who are taking affirmative actions to either facilitate or conceal illegal activity, I think that that's different from the scope of this bill, and which I believe encompasses, casts a wider net, and unfortunately will have negative effects on particularly the insurance markets for daycares and all kinds of other businesses that might be exposed to the costs of this implementation.
Any questions? You have a lot of questions. Senator May?
So I just need some clarification because, my apologies. I didn't hear the beginning of your testimony. So, good morning, first of all.
Morning, Senator.
Good morning. So what we're saying is that when we say retroactive, that means that if this law or this takes effect this year, you can retroactively, file lawsuits based on this law of things that are passed. Is that what we're saying? You get what I'm...
Yeah. So the as proposed, what SJR93 does, it would put a measure to the voters to give the legislature the authority to, by statute, approve an extended period for retroactive application of its existing child sexual abuse statutes for civil liability. And so the SJR93 does not automatically make civil liability retroactive. It authorizes a vote of the people and then gives the legislature the discretion to make that determination.
Okay, so it's going to the vote of the people. They're going to make a decision to bring to allow the retroactive to happen based on this legislation? Explain to me that process, because, you know, it's early in the morning, so evidently I'm not clear. I'm serious.
So from, again, were this to pass, it would be presented on a statewide vote either during the primary or general ballot.
Oh, I got that part. I'm talking about, so, an example of if, say for instance, you know, a lot of these abuses happen when children are in different educational facilities sometimes, or different, you know, camps for children. And when we're talking about retroactive liability, if it has already happened, is what I'm saying. Now we can go back and redress and get remedies. Is that that's what I'm understanding?
Yeah, were the legislature to adopt that policy after a vote of the people,
Yes.
that's what it would do.
Okay, and allowing to get remedies from
For civil damages, that's
for
correct.
civil damage from past injustices.
That is what would happen.
Okay, I'm just getting clarity. It's not a trick question.
Yep.
Thank you.
Thanks, Senator.
I know there were 33 states that were mentioned that have passed some form of this, and I know you mentioned one, California. Two states that I usually don't take into consideration, California and Illinois, for obvious reasons. So let's look at the other 32 states that have passed this. How have they done?
Sure. You know, as I also mentioned, the state of Maryland had a similar issue with the expansion of liability. So in 2023, they passed an extension for unlimited statute of limitations moving forward, and then retroactive application. Within 1 year, the state had 3,500 lawsuits filed against it. The state, their budget office identified that the state was exposed to $3.1 billion worth of liability, that they had already paid out $180 million within the first year, and that last year the legislature went back in and retooled that statute to cut the caps in half, impose attorney's fees, and then put a restriction on the recovery for basically apply that cap on a per person, not per incident basis. Because they were having a very dire budget situation. So the reason I bring those causes and those issues to this committee's attention is that there are serious financial consequences. The California report's informative because it identifies that after the passage of the California statute, there was a 700% increase on insurance prices for any public school or institution, and 85% of that marketplace left the market. So the concerns, obviously, victims, deserve to have their day in court. The perpetrators of this deserve to be held accountable, and the concerns that we're bringing to your attention are if the liability is cast so far to include what I'm describing as either non-perpetrators or entities that are not actively concealing or actively participating in this activity, it could have substantial effects like we've seen in California, like we've seen in Maryland.
Any further questions? Senator Brown.
You mentioned non-perpetrators, though it seems that it's limited to tortuous conduct. Was that one of the things that you referenced that weren't clearly enough defined in the bill? Is that what your issue is?
Senator, yeah, and again, the definitions specifically, I should say the terms specifically, have to do with the tortious conduct facilitating or causing an act to occur. In SJR93, the term is contributed to cause sexual abuse, and then 3 is the against any party for the tortious conduct. And so those are specifically the terms. And again, the concern is that they're not defined as what those entail. And so without an intentional act or some type of intent for those individuals, the general concern is, like in California or Maryland, that the net will be wide enough to get entities that are not actively concealing, but unfortunately would be defined under the statute as such.
So would that term not be defined in anywhere in case law that would be cited or anything in any future rulings where doesn't it kind of by nature indicate some kind of civil wrong like a breach of contract or some other action that causes harm to others?
Senator, those three descriptors are, to the best of my research, novel. I've not been able to identify their use in any Missouri statute, any comparable state statute passed in another state, or any federal civil liability statute. And that's why there's concern on that we're expressing about why that term is, what the intent of that term is.
And the states that you referenced, Maryland and California, I believe, were those laws, were they tailored specifically to the same sort of sexual abuse cases, or were those more broad?
The Maryland bill, which was passed in 2023, was tailored to a child sex abuse claim. The report for California happened, there were two bills, one passed in 2018, which allowed for lawsuits against public entities, and then another in 2021, which expanded the civil liability. And so the retrospective element in California was in the 2018 bill, and then they had a separate bill which addressed the prospective nature of liability.
Okay, thank you.
Any further questions? Seeing none. Next witness in support, please come forward. You'll have 5 minutes. Make sure you have your witness form filled out and clarify which bills you are in support of, 1140 or Senate Joint Resolution 93.
Thank you for allowing me to give testimony today. My name is Catherine Robb. I am the National Director of the Children's Justice Campaign at Enough Abuse. I'm also a national expert on child protection legislation and do a lot of this testimony across the country, by the way, including Maryland and California and about 32 other states. If I may, I'd like to hop into what the discussion just was, because I think it's really important. First of all, statute of limitation reform has really, really important implications for our children moving forward. It educates the public about the ubiquitous nature and the problem of 1 in 8 children being sexually assaulted before their 18th birthday. It also shifts the cost away from the victims, their families, and quite frankly, the taxpayers of Missouri, because they are bearing the brunt of this, the financial burden of this. But most importantly, what statute of limitations reform does is it exposes hidden sexual predators, and it also forces, to the point of the conversation that we just had, it forces institutions to have better practices, better procedures, better training, better reporting so we can protect children. So our view is always not just do we get justice for survivors. I am a mother of a survivor. I understand that personally. But more importantly is how are we protecting our children by sound public policy and really good laws? And that is to protect our children in the future. On the recent conversation, I just want to point out, and anyone who's an attorney in this room will know, that the criminal system has its limitations, right? We have data, and I'm happy to share this if anyone wants it, where less than 10% of sexual crimes against children go forward to prosecution. Right? So it's just a weak system. It's a higher burden. We have state attorney, district attorneys that have a lot of discretion. The victim really has very little voice. They're just a witness. They're not a party. So it's a system that does not work in terms of dealing with this social problem that we have, this public health problem that we have. The other thing is institutions don't go to jail, right? It just doesn't happen. It's just a much, much weaker system. May I point out that when I went to law school, and I took first-year torts, right, I did not study these types of harms. I studied car crashes and negligence, all of that. These are very unique harms. These are harms that are affecting children and people their entire lifetime. And as we've already heard, that it takes decades, if not a lifetime, to come forward. And the problem with that is, if we allow these laws to silence victims indefinitely, then what we do is we cover up the wrongdoers, whether they be institutions or not, right? The other point I'd like to make is that, look if you're an institution and you do the right thing, you have nothing to worry about. You have nothing to worry about because it is a negligence standard. You have to breach your duty to protect the children and then jump through that really, really tiny hoop of causation, right? And we still have the rules of evidence, we have the rules of civil procedure, we have, safety nets in place that all of these institutions are not going to go belly up. We see this scare across the country, right? The vast majority of states are dealing with this and say, hey, we've got it's a national problem. This is an epidemic. And we need to respond as lawmakers and as leaders to protect our children in the future. I failed to say, Chairman, I apologize, that I am in support of both SB1140 and SJR93. Just as to 93, I just want to point out that, as Elizabeth said, it's a very narrow amendment. And it is true, if I may just go another 30 seconds, sir. It's very narrow. But I also want to point out, I did a little look into history of Missouri and the Constitution here. It was adopted in 1820. We're all intelligent, reasonable people here. There is no way.
I don't know about all of us, but
yeah,
proceed.
Maybe not, right? But there's no way that the founders of the Constitution in 1820 in the state of Missouri understood this problem when they drafted that legislation, right? And clearly, if this goes to the people, they are going to want to pass legislation that will protect children into the future. Let me just end with this. Why should perpetrators and wrongdoing institutions be protected by the passage of time when victims and their families suffer in perpetuity? It is time to change the law here in Missouri. Happy to take any questions.
Thank you for your testimony and coming again year after year. One of the questions that I want to focus on with your expertise, looking at the 33 states that have enacted some form of this type of legislation, how have you seen them responding? How have you seen the crime numbers responding, these types of sexual cases in those 33 states? Is it deterring other cases? Is it cracking down on them? What has been the result?
So there's not a lot of data on that just yet. There's a little bit of data, but I do want to just make a quick correction. It's actually 33 jurisdictions because we have 2 U.S. territories. We also have the federal government. And by the way, a new bill has just been introduced into Congress about creating revival at the federal level for that federal statute that was...
Do you know who sponsored that?
I'm sorry?
Do you know who sponsored that legislation?
I believe it's Senator Ted Cruz.
Okay. That's what I was thinking.
Oh, that's Trey's law. No, but I can get that to you.
Okay.
Yeah, happy to get that to you.
And is it your belief that these types of laws, like you were stating, once the public knows, is that having a deterrent effect on these predators, or are they going to continue doing whatever they want to do?
I think if you look to any, crisis or disaster we've had in our country, right, it is when institutions realize that they are going to be subject to liability if they don't up their responses to this problem if they don't look the other way. I mean, look what's happened with the Epstein files, right? A lot of people look the other way. So if we are forcing institutions, and that's what we would be doing here, is to do the right thing by children, to have these better practices. Once they see lawsuits coming in, I can guarantee that all of these institutions, whether they be religious institutions, schools, camps, hospitals, right?
Well,
all of them.
on that point, we saw that during COVID. And I was general
Yeah.
counsel for businesses that were freaking out. They wanted to protect themselves, insulate themselves from liability, and they were putting in air cleaners, air scrubbers, and all sorts of things until the legislature crafted some legislation to protect them if they expose somebody to COVID. Before I open it up to questions, I know you mentioned at the beginning of your testimony that currently taxpayers are paying the brunt of this
Yes.
without this legislation. Can you expand on that? What do you mean by that?
Happy to, yeah. So when children are sexually abused, the science of traumatology tells us very clearly that they end up having all sorts of medical issues, behavioral issues. I mean, it's a very long list of depression, post-traumatic stress, educational issues. They can't focus because they're stressed and their cortisone levels are so high in their body. So what's happening, and we have data on this, is that social services are being impacted. Educational services are being impacted. Police services are being impacted. So all of the services that states provide to their citizens are bearing the heavy weight of the result of this high level of child sexual abuse. So it's really a burden on schools, hospitals, social services, you name it, it cuts across all services.
And if you could provide any of that information, statistics, or the bill sponsor, that'd be incredible.
Happy to.
All right, thank you. Any questions for the witness? Senator Brown.
Just kind of more a comment. Feel free to provide any commentary you may have or not. I think you made a great point as far as how this addresses an important issue of the victims for crimes that have already occurred, but also forward-looking, acting as a deterrent, and the importance of exposing kind of systematic type levels of this going on. And I know there's a statistic given in the previous testimony when they passed a law like this, the result was a cost of $3.1 billion, which is seems kind of staggering at its face, but at the same time, after hearing your testimony, it's kind of staggering in another way because, in a way, it reveals the extent of the potential problems that were there as well.
Well, if anything, that's a statement of exposure. That's a statement of how enormous this problem is and how many children, especially in Maryland, were abused through the foster system. It's a horrific read.
Well, thank you.
Thank you.
Further questions? Seeing none. Thank you again for your time. Make sure your witness form is filled out. And moving to the next witness in opposition, 5-minute testimony. And again, for everyone in the room, make sure you're letting us know which bills you're for, either Senate Bill 1140 and or Senate Joint Resolution 93. Mr. Aubuchon, you can continue.
Good morning, Mr. Chairman, members of the committee. My name is Rich Aubuchon. I'm here on behalf of the Missouri Civil Justice Reform Coalition. We are in opposition to both pieces of legislation. But that said, we have been working with the sponsor diligently, and we have also worked on this issue for years. Frankly, since 2018, even when we worked with Representative Corlew to make sure that the civil, or rather the criminal sanction for someone who committed this crime, this heinous, aberrant crime, mind you, would not be subject to a statute of limitations. And that was something the legislature did many years ago. At the time, the rally cry then was to seek justice, and justice then was to be ensuring that the individual would pay dearly with their freedom. In this particular instance, now we see that justice isn't enough. So what we're talking about now is holding everyone accountable. Well, we understand that. We will certainly not protect the perpetrator. That has not ever been our goal. Our goal that we have always had is to ensure that daycares, to ensure that providers of services such as church camps, Summer camps will be able to afford insurance and have a product so that parents can let their kids go to school, after-school care, etc. We're trying to protect the good employers. And that's all this discussion that we've had about over the last couple of years, and this issue has been. We have not been trying to say that the individual who has been hurt by a perpetrator should be protected. That's never been the discussion, and I hope that the sponsor can confirm that. The talk that we're having, though, is the broad blanket applications of statute of limitations to employers for negligence. When we talk about narrowly tailored, that's not what this bill is in this respect. Narrowly tailored would be finding those bad actors and holding them accountable. But to do so, you have to craft the bill so that the language of it directly goes towards those bad actors, and that's what we're trying to do, and I think that we will hopefully come up with a resolution this year to do so. Last year we were so close. I think that we've heard one other comment in regard to institutions are not something that you can put in jail. Remember, institutions are run by people. They're not faceless, companies out there. These are individuals. So if an individual who operates an institution, a company, a nonprofit, for-profit, etc., has done something in a criminal, the institution doesn't shield them from the crime. So if this individual who's done something in a criminal context, they should be held accountable for that as well. And that's the type of, I think, the discussion that we're having with the sponsors to try to find that blend so that good employers who've done the right thing, who've merely been negligent in their hiring or their retaining, but haven't taken the narrow step of going into a criminal act of protecting or furthering or even fostering the environment for that individual to commit a crime. That's the kind of thing that we're trying to find.
Thank you for your work on trying to find the middle ground. I know you and I have had discussions on how to treat the bad actors, how to treat the business owners that may be a little bit lazy and delegating some of these authorities to other people, and it just falls through the cracks. Or if they've heard from whistleblowers what's going on, but they choose not to take action. Those people need to be held accountable, and in my opinion, I don't think this bill goes far enough in that regard. I'll save those comments for a little bit later on, but want to open it up to any questions for Mr. Aubuchon. Senator Brown.
Just wanted to clarify kind of the position that you're taking on this. So do you in favor of expanding the statute of limitations for the victims, but just your issue is with the tortuous conduct portion?
So let me clarify, at least in the respect. We have to testify in opposition to the expansion of statute of limitations. We have been working on a framework that would allow for the expansion of the statute of limitations in situations where the perpetrator was the one and also a bad actor. We are very concerned about having a broad application of a statute of limitations for any business simply on negligence.
So the framework that you'd support would be just limited to the person actually committed the crime?
Yeah.
Okay.
And that could also include a third party who committed the crime who wasn't necessarily the perpetrator but may have helped that person.
Okay, thank you.
Yeah.
Further questions? Seeing none. We're going to now move to those in favor at the 3-minute mark.
Gracia, Max?
And show of hands, is there anybody here for informational purposes? I forgot to ask earlier. All right. Proceed when ready.
Good morning. My name is Gracia Max. I am the Executive Director of the Rise and Reclaim Advocacy Group, a nonprofit that helps survivors of abuse within religious institutions. I am also a childhood sexual abuse survivor and a sexual abuse survivor of the International House of Prayer, Kansas City, IHOP-KC, founded by Mike Bickle, a man who has been publicly accused of sexual abuse and misconduct by 17 women, and with an insurmountable number of other sexual abuse survivors emerging from his organization. I have traveled over 500 miles for a second time to come before you on behalf of the survivors of IHOP-KC because many of them cannot pursue civil accountability, not because what happened to them wasn't real, but because Missouri's clock runs out before the survivors are even able to speak. Today you are hearing 1140 and 93, These two must move together, or Missouri will keep doing something unconscionable, acknowledging the devastation of childhood sexual abuse while still protecting the predators and institutions that benefit from silence. Senate Bill 1140 fixes the future. It allows civil actions for childhood sexual abuse to be brought at any time. That is what Missouri should have done a long time ago. But that alone does not fix the present. It does not empower the survivors who already missed the deadline, who disassociated, were threatened, were spiritually controlled, or whose memories only surfaced after decades. These are survivors whose abusers weaponized time. Under current Missouri law, the courthouse door doesn't close because the abuse didn't happen. It closes because the survivor didn't heal on a legislative timeline. That's why SJR93 matters. It removes the single most reliable shield abusers and institutions have ever had, the calendar. For IHOP-KC survivors, the passage of these bills would do what years of statements, apologies, and internal reviews never have: force the truth into daylight. Many people have publicly alleged sexual abuse and misconduct from the leadership of IHOP-KC, alongside documented failures of them to intervene, report, and protect. And yet Missouri law has functioned as the final layer of insulation, ensuring that even when survivors are finally ready to speak, the institution never has to answer. The truth is, the pain of trauma has no expiration date. Why should accountability? If you want the most honest sentence I can say to you today, it's this: a statute of limitations is not a neutral policy. It is a weapon. And in child sexual abuse cases, it is almost always wielded by the guilty against the wounded. Last year, you helped Missouri prove something important. When you see injustice clearly, you can act. The state moved to void NDAs that silence sexual abuse survivors, known as Trey's Law, because Missouri finally said out loud that secrets protect predators, not children. Now it's time to finish the job. The current law isn't neutral, it's negligent. If justice requires a child to process trauma on adult timeline, justice was never designated for victims. With this bill, we do more than update the law. We rewrite the narrative. Let's declare together, loud and clear, that Missouri stands with survivors. They are owed healing more than their abusers are owed immunity for their crimes. Please advance Senate Bill 1140 and SJR 93. Please do it with the clarity this moment requires. Missouri should never be a safe harbor for child sexual abuse by policy, by procedure, or by delay. Thank you.
Thank you for your time, and thank you for coming again. I know you were here last year. Any questions? Senator Schnelting.
Thank you very much for being here. You know, I've got to say, so my sister, my younger sister, had gone to IHOP-KC, and so I'm just going to say, anybody who thinks about the faith and thinks about Jesus, one of the things that he did was he consistently stood up for the handicapped, the disabled, the sinners, the tax collectors, the outcasts. He always stood for the vulnerable. And anybody it takes a special kind of evil for a person to take the sincerity and the purity of Christ and to hide behind it and to use it as a shield to harm the innocent and the weak. So the work that you're doing, the work that Elizabeth is doing, and the work that all of your groups together are doing, I very much appreciate you being here and speaking out, having the courage and the boldness to do that. So that's it, just the comment, Mr. Chair. Thank you very much.
Thank you so much.
Further questions? Senator Berger, please proceed.
Thank you for being here also. I'm new to this committee. So is IHOP-KC something that is still going on?
Yes.
So give me a little background on that, please, as far as who that is or what that is.
The International House of Prayer is run by Mike Bickle. It is a 24/7 prayer house located in Kansas City that started, I believe, in the 90s. It brings in thousands of interns, students, staff members every year, or it used to, until my story and two other stories came forward in the fall of 2023. exposing them for sexual abuse. And with that, an avalanche of other victims started coming forward, accusing both Mike Bickle and the leaders that he instated of both sexual abuse and the covering up of sexual abuse institutionally. Their response to it was to cover it up, to hide it, and to continue to deny it. They have since then lost most of their staff, most of their funding, most of their programs, but they are still functioning. They are still avoiding accountability, and Mike Bickle is still running free.
So people are still attending this?
Yes.
Okay, thank you.
Thank you.
I know a lot of people have said that the criminal justice system is going to fix these perpetrators, but you just said that there are a lot of people who've come forward. Do you know how many people have come forward saying that Mike Bickle was a perpetrator?
There are 17 public-facing survivors of Mike Bickle. Some of them were as young as 14.
And you said this, at least your story came out in 2023. It's been several years, and he's still operating a business. He's still walking free. Have there been any criminal cases filed against him?
No, because the statute of limitations has run up.
I guess I'll comment. I mentioned earlier, I don't think this bill goes far enough. I know Senator Moon has a bill dealing with the death penalty for child sex offenders. And I think that should be ushered through. I hope that gets into our committee so we can fast track that. I think for these types of individuals that Senator Schnelting was saying, hide behind the Word of God and masquerade as some sort of spiritual leader to prey upon kids, they need to be dealt with. And I think Senator Moon's bill is appropriate for that. Any further questions? Seeing none. Thank you again for your time.
Thank you very much.
Mr. Schlemeyer, you'll have 3 minutes. Make sure you testify which bills you are in favor or opposed to. Thank you.
Thank you, Mr. Chairman, members of the committee. Organ Schlemeyer on behalf of American Tort Reform Association. I filled out one form for both bills. Is that? I assume. Okay, thank you. We are opposed to SJR93 retroactivity. We are interested in working and have been working with the sponsor on Senate Bill 1140. One quick note, Mr. Chairman, I think you just asked the previous witness. There is no statute of limitations on criminal activity. They can be prosecuted at any time of their life. I will also say it doesn't just take a unique person, it takes a mentally ill person to commit this. There's no doubt about it. There is nobody in their right mind that would ever do these kinds of acts. Going forward, we do believe that there is certainly room for expansion of statute of limitations for the perpetrator and also for the bad actor, and including the bad actor can be the employer, and we want to continue to work with the sponsor and try to get to that resolution. Thank you.
Just want to drill down on that point. I know Mr.
Yes.
Aubuchon and you have both said that, and I know in private meetings you said the same.
Absolutely.
That you're willing to work and craft some sort of legislation that would penalize civilly
Yes.
the perpetrator, the pedophile, and the bad actor. And that could be the business shielding them or allowing them to continue working in that capacity with children, knowing that there were reports of horrific behavior.
That's correct, Mr. Chairman. I think the just maybe to kind of clarify one point when you said on the perpetrator, I think what you're looking for, I'm not sure we're seeking any language to, because I think that I think the ability to civilly go after that person exists today. I think what you're looking for there is an expansion of statute of limitations. So I'm not sure I have a proposal to change the standard by which you can sue somebody there. And maybe you all do. That's fine with us. That's up to you all. It's the bad actor trying to figure out if you want to expand the statute of limitations on the third party. That's probably more specific of what we're interested in trying to further define.
Further questions? Seeing none.
Thank you.
Thank you. Moving back to those for the bill.
Logan Yand.
Logan?
Howdy.
Thank you.
I'm going to read mine because I'm not good at just speaking off the cuff. So, Chair Schroer, is it? And members of the committee, thank you for the opportunity to testify. My name is Logan Gregory Yandel. I live in Nashville, Tennessee, but I'm here today because Missouri played a significant role in my childhood and in my harm. I spent a great deal of time in Missouri growing up. It is where I was sexually abused at Kanakuk camps in Branson. Because of that, Missouri law, not Tennessee law, determines whether I and others like me can access the civil courts. I am testifying today in support of both SJR93 and SB1140, with a particular emphasis on SJR93. Missouri has taken meaningful steps in recent years, and because of reforms already passed, survivors of child sexual abuse can no longer be silenced by non-disclosure agreements and civil settlements. That matters. It shows a commitment to transparency and child safety. But despite that progress, there remains a fundamental barrier in Missouri law, one that cannot be fixed by ordinary legislation alone. SB 1140 is an important and necessary bill. It prospectively removes the civil statute of limitations for childhood sexual abuse, ensuring future survivors are not forced to disclose on an unrealistic legal timeline. That reflects how trauma actually works, and it aligns Missouri with reforms that many other states have already adopted, which you will likely hear referenced and I think already referenced in testimony today. However, SB 1140 does not help survivors whose claims are already time-barred, as has been explained before. That is why SJR93 is absolutely essential. Missouri is the show-me state. SJR93 reflects that value. It does not ask anyone to assume guilt or accept allegations at face value. It simply says, show the evidence, let the courts evaluate it, and allow the truth to be tested through the judicial process. Just as importantly, SJR 93 puts this decision in the hands of Missouri voters. This resolution does not change the law by itself. If passed by the legislator, it goes to the voters of Missouri, who would decide whether to narrowly amend the Constitution to allow retrospective civil laws only for childhood sexual abuse claims. And even then, the legislator would still have to act again to create a revival window. In other words, SJR 93 does not impose a policy choice. It respects Missouri voters by giving them the final say. SJR does not create liability. It does not mandate retroactive lawsuits, and it does not decide guilt or innocence. What it does is remove a constitutional barrier that currently prevents any consideration at all. Allowing a claim to be filed does not guarantee an outcome. Courts still evaluate evidence, defendants still raise defenses, judges still dismiss cases that cannot be proved. SJR 93 simply allows that process to work.
While your time has expired, I'll give you a couple more seconds to summarize.
Just to touch on the comments from the gentleman from the Missouri Insurance Coalition and others in opposition to these bills, Missouri should not prioritize profit over protecting children. Also, institutions such as Kanakuk are perpetrators, and the bad actors or people who run these organizations are perpetrators as well. Thank you for your time.
Thank you for your courage in coming here today. If I was in Nashville, I probably wouldn't leave. What are you doing in Nashville right now?
I own 2 Ace Hardware.
Okay.
Yeah.
Are you a country music fan?
Yeah, I worked in the music industry for a long time.
Do you have any position on Waylon Jennings being the greatest outlaw country musician of all time?
That's a hard one. I'm somewhat related to Johnny Cash, so I'm a little partial. But Waylon is one of my favorites.
Oh, Bob Wills is still the king down in Texas.
Absolutely, yeah.
Going back to Kanakuk, how old were you when you were at their facility?
So I started going to Kanakuk when I was 7 years old. I was abused from 9 till 13.
Are some of those perpetrators still there at Kanakuk?
We know
that you're aware of.
We know of over 75 individual perpetrators that have come through Kanakuk's gates. Hundreds and hundreds of victims that have come forward to an organization called Facts About Kanakuk. It's well documented. We know of perpetrators that have been at Kanakuk or involved with Kanakuk that still have not been held accountable. And that's how I'll address that question, to respect other people's stories. I don't want to tell anyone's story other than my own.
And your
my perpetrator was Pete Newman. He lives down the road at the corrections facility here in town.
And your story was, you were muzzled for so long, up until last year, correct?
Yes, I was put under an NDA.
And now you're free to talk about what happened.
I'm free to talk about what I broke my NDA by filing a fraud lawsuit against Kennecott. The Trey's law in Missouri, I don't believe was retroactive. Yeah, it was not retroactive. So technically, the law does not allow me to talk, although I am under an NDA. But Kennecott also broke my NDA by disclosing the information about my abuse in a public lawsuit as well. So we both broke it, I guess you could say, but I broke it first by suing them for fraud. Yeah.
I look forward to all of that discovery process.
Yeah, look it up.
Will do.
Yeah, appreciate
Again,
it.
thank you for being here today.
My pleasure.
Any questions for the witness? Senator Berger.
Thank you for coming forward. Appreciate that and being here today. You were abused from age 9 through 13.
Yes,
when
sir.
did you make people aware that you were being abused?
My perpetrator, Pete Newman, was first reported to authorities in 2010. That was a decade after he had been caught acting inappropriately or sexually abusing children on the camp's premise. That was made public, and then I was a part of the I was a part of his sentencing process. I was, like many other victims, I held that alone until I was about 14 or 15, until my parents approached me and asked me if, anything inappropriate had happened between us, and in fact it had for a long time, which was not surprising because I was very close with Pete for many years.
I'm sorry you had to endure that, and thank you for being here today.
Yeah, I greatly appreciate you guys.
Thank you for bringing a little sunlight to this committee, talking about Johnny Cash, Waylon Jennings, and
Of course.
and the actual home of country music, which I believe is in the sponsor's district.
There you go, Branson, Missouri.
Absolutely. Any further questions? Seeing none, we're going to go back to those opposed to Senate Bills 1140 and Senate Joint Resolution 93. You will have 3 minutes.
Good morning, Mr. Chair, members of the committee. My name is Jared Hankins, and I serve as the Vice President of Government Affairs for the Missouri Chamber of Commerce and Industry. I want to start with acknowledging the strength, bravery, and courage of all of those that have spoken, given their personal testimony, their personal experience here today. Appreciate everyone taking the time to do that. And as the other opposition witnesses before me have mentioned, we look forward to collaborating through our partnership with the Civil Justice Reform Coalition and with Senator Hudson to ensure that those individuals are empowered to hold those bad actors and those perpetrators of these heinous crimes accountable. Our concern with the language before us in both Senate Bill 1140 and SJR93 does come with the breadth of the extension of liability to some of the businesses. We do think that there's a pathway to narrow and tailor that to bad actors, and we look forward to participating in those conversations to come to a compromise. I'm happy to take any questions.
Any questions? Seeing none.
Thank
Thank
you
you for your testimony. Moving back to those in favor, Senator Hudson.
Connor Ward.
Connor. You'll have 3 minutes. Make sure you illustrate which bills you're in support of and begin when ready.
Good morning. I'm in support of SJR93 and SB1140. I want to say thank you for the privilege to testify and be in front of you all today on these bills. I appreciate this opportunity, and I believe this opportunity we have today will give more victims a voice, specifically children of abuse, and to remove safety nets that pedophiles have been able to live under. That's my goal. My goal is to make this state where the majority of my abuse happened safer for kids. For the last 25 years, I've either been identified as or I've identified myself as John Doe. As a 34-year-old, I no longer want that to be my identity, and for the first time when talking about sexual abuse, I'm going to use my name. My name's Connor Ward. I use my name now because I'm confident, strong, courageous, and also because Trey's law was passed in Texas, which is where I live, and I no longer have an NDA silencing me. When I was under 10 years old, I was groomed and molested here in Missouri. From that age on, I dealt with guilt, anger, sadness, confusion, and frustration. I was traumatized and felt vulnerable. My world was flipped on its head. It was a very dark and lonely place to be, and being that it happened at such a young age, I did not know if what happened to me was normal or not normal. I did not know how to even bring up what happened to me. There was so much guilt and confusion that I was lost. My grades in school started to slip, friendships became more difficult to have, and anger took over as I grew into my teen years and 20s. Those are supposed to be such magical years. I would look around and see others seem to have what was a great life, while every single day I was living with so much anxiety. It has taken decades for me to get to a point where I can finally be at a place where I've accepted that what happened to me was not supposed to happen, and I can look back at myself as a survivor. Thankfully for me, I have an amazing wife, mom, dad, brother, sister, friends, and extended family that have been a support system for me. Not everybody has that, and not everyone has the access to counseling, and not everyone has a person that they can go to in confidence and tell their story. And we should not expect children to have that understanding or the resources to go about that properly of addressing their sexual abuse. On average, it takes 23.9 years for a child to come and tell someone about their abuse, and a third of individuals never tell anybody. If that's the case, why do we put timelines on children to act on the abuse they encountered? Why are we making it harder for children who went through such horrendous acts to come forward and heal? Based off my journey I went through to get to where I'm at today, I cannot sit in silence where there's laws in place that protect pedophiles and institutions. Having restrictions on children who went through abuse on how long they have to come forward and talk about what they experienced and heal will only harm victims. As I said at the beginning, my goal is to make this state safer for children. With that, I ask you, will you stand with children that went through abuse? Will you make this state a safer place by preventing pedophiles from retribution? I ask for you to stand with me with SJR93, SB1140, because until there is change to the statute of limitations, more John Does will suffer in this state due to Missouri's inaction. Thank you.
Thank you, Connor. Thank you for being here and the bravery for telling your story. Coming back to Missouri where all of that happened. To apologize on behalf of the state of Missouri that this happened to you. We're going to do our best to make sure that this doesn't happen to anybody else. But again, I want to thank you for your bravery. You're a rock star for being here today. Any questions for the witness? Seeing none. Moving back to those in opposition. Seeing none. Informational purposes. Seeing none. Any more in favor of either Senate Bill 1140 or Senate Joint Resolution 93? Please come forward. You will have 3 minutes.
Good morning. My name is Penny Minetti. I'm a licensed trauma counselor, an EMDR practitioner, and a consultant specializing in PTSD recovery. I'm one of approximately 50 counselors serving Missouri's first responders through the First Responders Providers Network. I'm also a Christian author and a former nurse at Kanakuk Christian Sports Camp, where my own children were campers for 6 terms and later staff members during the very years that Pete Newman was sexually abusing children. I loved Kanakuk. I was one of their biggest supporters. I loved the energetic ministry, entrusted my kids, referred countless families, and served proudly as a nurse. When rumors surfaced about abuse, I investigated about Newman. I immediately met with Director Chad Hampsch. He confirmed the abuse, shared horrific details, and assured me new safeguards were in place. I believed it was isolated. I had no idea NDAs were silencing victims of that, or that abuses were far more widespread. My son, a counselor responsible for approximately 10 campers, said that he was entirely unaware of the prior crimes of camp property, what signs of grooming or abuse to watch for, or how to report concerns, or how to protect campers. The myth that time heals does not pertain in PTSD. Our brains have 25 quadrillion neural pathways that store sight, sound, touch, emotions, and belief with each experience. Neural pathways have no sense of time. They do not age. That's why when you smell apple pie, you think of Grandma. When the veteran hears fireworks, he dives under the bleachers. When a survivor with unprocessed trauma becomes triggered, those neural pathways bring them right back to relive their terror over and over and over again. They feel the abuser's breath when they're in a crowded area. When they are not having flashbacks and intrusive thoughts during the day, they're having nightmares at night. Many self-harm just to feel something. Eating disorders emerge. They try to escape and numb the pain through drugs and alcohol, and some, like Trey Carleck, they escape the unbearable hopelessness permanently through suicide. I teach survivors you don't have the power to change the past, but you do have the power to choose how to respond. You can turn your pain into purpose, but NDAs and statutes of limitations rip that power away. They gag survivors, denying them the voice needed to process trauma and therapy, to hold abusers accountable, and to transform suffering into meaning. NDAs and statutes of limitations actively re-traumatize, trapping survivors in silence, their prison of solitary confinement. Evidence-based research shows that silencing survivor increases the chances of mental health disorders, and the trauma treated in the first year decreases mental health.
While your time has expired, I'll give you about 10 more seconds.
Okay. I'm currently treating 11 siblings ages 16 through 32 who suffered unimaginable abuse, torture, and terrorism. Their parents are currently incarcerated, awaiting trial for sodomy and murder of their 13th child. When we began treatment 15 months ago, they had no birth certificates, were not born in a hospital, they had never seen a doctor or the inside of a classroom. They did not know what their faces looked like until they escaped and saw a mirror for the first time. Missouri's current statute of limitations bars the claims against negligent organizations that are in place to protect, and their justice is halted.
Any questions for the witness? Any closing remarks? I'll just give you a few seconds left.
Thank you for letting me speak today. And survivors and their families, not only from Missouri but worldwide, are watching you. So what you do with this bill. So I just ask that you give abuse survivors their God-given voice back. Thank you.
Thank you for coming today and your testimony. If you want to leave your written testimony there, we can distribute it.
I'm sorry?
If you want to leave your written testimony, if there was anything else, we can distribute it to the members. By show of hands, anyone else here in opposition? And show of hands for this bill. Okay, well, we're going to have to move it to 1 minute because we have another bill in executive session. So the next witness, please come forward. You will have 1 minute.
Good morning. My name is Chad Puckett. I'm the president of the Missouri Association of Christian Child Care Agencies, and I just want to come out in support of this legislative effort as well as others that are going through the Senate now to provide an additional layer of protection for children and prevent these things from happening. I just have to say I texted a group of my close Christian friends that to pray over this today, and one of them responded with a text, simply Proverbs 8:14, all who fear the Lord will hate evil. This is what we're dealing with. This is a different form of indescribable evil that's perpetrated on our children. And there should be no safe harbor, no safe place for a predator at any time. And children should, when they have the opportunity and realize that harm has been done to them, that this is not natural, they should have the ability to pursue damages and recover their life. And that's what this bill intends to do. Thank you.
Thank you for your time today and your testimony. Any questions for the witness? Seeing none. Next witness in support. Make sure you mark on your witness form which bills you're in support of, and you will have 1 minute. Thank you.
Hello, my name is Anna, and I am in support of both bills. These are pictures of myself and one of my siblings. In 1996, in my mid-20s, I finally found the courage and voice to tell my family of the abuse I had suffered as a child for years. Naively, I thought I was the only one. I was wrong. It was every single child on that side of my family that had been abused by the same family member. When we researched the law at that time, we realized we had no legal recourse. I contacted my state representative, and it took us 2 legislative sessions, but in 1997, we actually passed the statute of limitations to 10 years past the age of 18. And yet that law was not retroactive. Our abuser still has no accountability, none. And I guarantee you he is still abusing to this day. I wish I had the time to tell you the tsunami of devastation this predator caused in my family, because it did not leave one person unscathed. Alcoholism, drug addiction, prison time, violence, an accidental drug overdose that led to death, verbally and emotionally abusive relationships, depression, anxiety, fear. But there's one thing that is almost as equally as debilitating as the abuse that survivors endure. It's called silence. Over the years, I've been told that I shouldn't talk about the abuse. It's not polite conversation. I should get over it. And even my own grandfather, who I loved and adored, when he found out about the abuse, he told my mother, "Please don't do anything about it until I'm dead and gone." Can you imagine? The very people that are supposed to protect us are more worried about how it's going to affect them. Just like what some of these insurance companies are telling you, they care more about what is going to be happening to them than they do about protecting our children. Missouri has made strides, but we are not finished. There is no statute of limitations on my suffering or my abuse. Why should there be none for accountability so we can protect children?
While your time has expired, I'll give you about 10 more seconds to wrap up.
Thank you. I just want to add that this is not about financial gain. It's about ensuring survivors are not silenced. It's about protecting our children. And I would counter that in the long run, it will save insurance companies money, because once they shine the light in the dark, they will know who the bad characters are, and they won't have to insure them anymore.
Thank you for sharing your story today and having the bravery to come forward before the whole committee. Any questions? Seeing none. Next witness in support, you'll have 1 minute.
Good morning, Senator Schroer and members of the committee. Thank you for your time today. My name is Ryan Frazier. I am an attorney in Missouri, and I represent victims of childhood sexual abuse. The hardest thing I have to do in my job is to listen to victims' stories, these horrible stories, and tell them that there's nothing that I can do to help them. Not because I don't think they have a case, not because I don't think the evidence would support them in the courtroom, but because the law doesn't allow it. Just yesterday, I spoke with a victim who's now 32 years old and just came forward with what happened to him. And to summarize what he said as to why he's just now coming forward, he said that when his parents asked him at a young age whether anything had happened, he felt deep inside of him that the only answer that he could give was no, because that's the answer that would lead them the least amount of pain, and that's the answer that would make it not real. And he convinced himself over the next 15 years that that was the right answer, even though it wasn't. I want to address briefly some of the things that have been brought up in opposition, mainly this bad actor standard and some of the definitions in the legislation. Sorry if
I'll give you a couple seconds to wrap that up.
Really about the tortious conduct and that not being defined, that being a vague term. Like Ms. Robb said, torts is the first class you take in law school. It's very clear under common law what a tort is. We don't want to change what a tort is. There's been hundreds of years of law and case law about what makes a bad actor. We don't want to change that in this legislation and limit what the courts have already determined who is a negligent bad actor in the court system, and we don't.
And Ryan, any other testimony you can submit in writing or send to me, and I'll distribute to the committee. Are there any questions? Seeing none. Thank you for your time.
Thank you.
Next witness in support.
Good morning. My name is John F. Hobbs from Lisa, Missouri. I'm a long-standing survivor of childhood sexual abuse by a former doctor, counsel, medical director, and now convicted felon Joseph Mackey. I want to thank everyone so much for having us here. This is just so critical and essential, and I know we're down on time, so I'm going to just get right to the point. Certainly not proud to be one of the most versed people anywhere on this issue, but let me just state a few things as to why. My life's path highlights exactly why this is essential to get this into law, okay? So I was abused, groomed up until about age 14, and abused from age 14 to roughly 25 while I was an employee for the Heart America Council Boy Scouts Okay, I disclosed then they concocted a scheme with the now convicted felon along with the people that we're talking about today that, and I'll just hold on names, but that have ascended up to very high-ranking positions and frankly were basically allowed him to get off scotch-free, basically. He should have done about 20 more years.
While your time has expired, I'll give you about
Sure.
10 more seconds.
Sure, I appreciate it. So, and again, this is not about civil lawsuits. This is not about money. I didn't want to leave my job. This is about accountability, okay? And everyone that's spoken on this issue has really hit a lot of the points, but it is so critical to understand that criminal and civil law do intercorrelate, and this solves that issue, okay? This solves that issue. And frankly speaking, there probably would have never even been a civil lawsuit in my situation had I just been able to be supported through the situation at hand. And so, you know, there's a lot more I could say. Obviously, we have a huge rallying, you know, group of scouts across America, IHOP, Kansas City, Catholic Church, Kanakuk Ministries. You know, at some point we got to say, okay, we got to deal with this. And I really appreciate the passion and certainly witness to any, you know, thing going forward. If you guys have any information, happy to provide it. But you know, it's just so sad to me that you know, we have an opportunity. Let's get it to the voters. Let's get it enshrined. Let's move forward so we can, like they're saying, this will save the insurance industry. You know, I'm tired of hearing that BS. I mean, it's ridiculous. It will save them down the road. So, and if there's any situation that's going to be the flag bearer on that, it's going to be my life story and what's continuing to go on this day.
Thank you again for coming. You were here last year and I think the year before.
Yeah, many years now, frankly.
Well,
Yeah.
thank you for fighting for this this issue. Any questions? Seeing none.
Thank you so much, guys.
Next witness in support, you'll have 1 minute.
Appreciate it. Let me know if you need anything.
Good morning. I'm Jessica Seitz. I'm the Executive Director of Missouri Network Against Child Abuse. And I think you can hear from the buzz in the room. Our organization believes that this is a generational opportunity in our state. We know that child sexual abuse impacts thousands of children and has every year. And right now, our statutes and our Constitution have narrowed those pathways to justice. So we can open up the pathways for those that have experienced abuse. But I also want to make a point that in states that have opened up revival windows, it has exposed institutions and predators. We can open that and potentially make some of those institutions safer. So we've talked a lot about remedies. That's wonderful. We can also protect our children of the future here. That's how important this is. Thank you.
Thank you. Any questions? Seeing none. Next witness in support.
Good morning. I'm the CEO of the Missouri Coalition Against Domestic and Sexual Violence. My name is Cheryl Robb Welch. On behalf of myself and my members, we are in support of both bills because these bills are about time. Throughout my career, I've witnessed victims' healing journeys and know that it takes time to determine who it's safe to disclose to, time to feel safe and strong again. It takes time to determine what is next for healing and in seeking justice for the wrongs done. These bills afford the victims time they need to seek justice, so on behalf of our members and the survivors of childhood rape and abuse, we urge you to support both bills before you.
Thank you for your testimony today. Are there any questions for the witness? Seeing none. Next witness in support. Please proceed. You'll have 1 minute when ready.
Good morning, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dienoff, State Public Advocate. And you know, enough is enough. These victims have endured and felt a lot of hardship. This is common sense legislation. It's a no-brainer. SB1140, SJR93, giving the rights of citizens to vote. I think it's going to be overwhelmingly that we will change our Constitution. Citizens, children, abuse victims have gone through tremendous trauma, anguish, and mental health issues. This changes and limits limiting bringing causes of action and lawsuits civilly. Stop protecting sexual, creepy, insane pedophiles, child or other sexual abusers is wrong public policy for our state. The current law is giving a free pass to these atrocious devils. It's allowing a culture of mentality to go on and on for generations and generations.
While your time has expired, I'll give you a couple more seconds.
Thank you so much. By silencing and shutting up Missouri victims is sacrilegious. Missouri and County Circuit Court juries know and will vote what is right for Missouri victims at any time that this abuse is discovered. Lobbyists should not be protecting bad Missourians, insurance proceeds and profits, and liability for harm and pure evil. For those reasons, I support SB 1140, no statute of limitations or torts, to commence civil remedies at any time, and SJR93 by passing this bill and amending our state constitution. I believe this will prevent and be a clear message that abuse and preying on children will not be tolerated in our state whatsoever. We need to send that clear message. Thank you, Mr. Chairman.
Thank you, Arnie. Any questions for the witness? Seeing none. Next witness in support.
Thank you.
Any for informational purposes? Any in opposition? Seeing none. Any closing remarks?
Real quickly, Mr. Chair, I'd like to leave you with these words. Ephesians 5:11, and have no fellowship with the unfruitful works of darkness, but rather reprove them. God's children are called not only to avoid evil and darkness, but to expose it. I want to thank you. I want to thank the members of this committee. I want to thank the brave witnesses that we've heard today for helping me to fulfill what I believe is not only a duty to my constituents, but a calling from my Creator. Thank you for the time.
Thank you. That'll conclude the public hearing on Senate Bills 1140 and Senate Joint Resolution 93. We're now going to move to a very efficient hearing. Senator Schnelting, I know they indicated that I was the senator from St. Charles, but there's another one, and I'm going to hand the gavel over to you so we can present Senate Bill 1392.
Thank you, Mr. Chair. Just go ahead and proceed when you're ready.
Thank you, Mr. Chair. This is Senate Bill 1392. For the record, Senator Schroer from St. Charles County, the St. Charles County. Presenting the bill that we had last year. This is the mirror image of Senate Bill 531. It appeared in Senate Bill 575. It was also House Bill 1045 from last year. Essentially, what this does is provides in our criminal code that a person will commit the offense of murder in the first degree if they knowingly deliver or distribute fentanyl or carfentanil, the derivative thereof of fentanyl, that is much stronger, more dangerous than fentanyl, and a death ensues or death results from the use of that substance. The knowledge requirement is part of this, so if somebody laces marijuana or some other drug with fentanyl or carfentanil or any derivative thereof, and the person dies from using that drug, then they would, the prosecutor would be allowed to charge them with murder in the first degree. We've seen much like the last issues that are plaguing society, fentanyl and carfentanil are doing the same thing. So with that, I will open it up to any questions on making this an A felony. If the person is over the age of 18, and the punishment shall either be death or imprisonment for life without the possibility of parole. Any questions?
Thank you, Senator, for bringing this forward. Accountability is vitally important. Any questions for the bill sponsor? Senator Berger, proceed when you're ready.
Thank you for bringing this forward. Why would we have the age of 18 in there, just because of the juvenile aspect of this? Or?
Yeah, and we can explore that, but yeah, the juvenile aspect of it, I'm hoping that no one under the age of 18 would be partaking and using fentanyl and lacing it and selling it to people. But it's just kind of sort of a compromise to figure out, let's catch the majority of these bad actors and deter any children from doing this themselves.
You know, what would concern me is people that are working for people that use 16-year-olds to do their work. I just don't think we ought to let them off the hook. I think it ought to be all-inclusive of every age.
Yeah, I think this bill is going to capture the bad actors who are utilizing kids. We've seen that in a lot of the street gangs and organizations that are using these kids because they think they can get off the hook. But essentially, we're gonna hopefully, with the passage of this bill, get the bad actors at the top of that ringleading organization. But yeah, I'd be more than happy to explore getting the youth captured in there as well.
Thank you.
I would say further questions, but we're it right now.
Eric, do you have any questions?
Right. We'll go ahead and enter into public testimony. Is there anyone here to testify in favor of Senate Bill 1392? Go ahead and come on up. Down to 30 seconds. I've got 1 minute. Just go ahead and proceed when you're ready.
Good morning, Mr. Chairman, members of the committee. My name is Arnie C. A.C. Dienoff, State Public Advocate. And I first want to start out by this bill, SB 1392, is needed. I could tell you experience after experience in St. Charles County and other parts of the state that I have seen people pass out and be brought back to life with Narcan because of the use of fentanyl. This is a no-brainer legislation. Murder in the first degree, a felony A is warranted. We have some bad actors who are out here who are trying to cut corners and lace fentanyl or methamphetamines with some scrupulous chemicals that do a lot of damage to individuals. Now, I don't condone or believe in using these drugs. I think it's wrong. I think it's inappropriate from the drug trafficking that's happening from South America up into our southern border. The terrible human that laces these drugs with bad chemicals needs to be held accountable to the highest degree. I do believe that accountability and responsibility of the person doing this crime needs to either face life in penalty or possible death penalty by a jury of the person's peers. For those reasons, I am in support of SB 1392. Thank you, Mr. Vice Chairman.
Thank you. Any questions for the witness? All right, seeing none. Thank you very much for your testimony. Anyone here to testify in opposition to Senate Bill 1392? Anyone here? Okay. Come on. Go ahead and come on up and just proceed when you're ready, sir.
Good morning, Senators. My name is Jeff Stack. I'm with the Mid-Missouri Fellowship of Reconciliation. The deaths of anyone are horrific when you think in terms of fentanyl and other drugs. We need to condemn them, indeed, those actions where people get such drugs. Our group, the Fellowship of Reconciliation, we're interfaith and believe that the death penalty is wrong across the board, that life is given to us by a creator, that life should not be taken by other human beings in any situation. I think that no magic occurs. Unfortunately, we execute somebody and the person who lost their life doesn't come back to life. There's no way we can redo that horrible situation. I think it's also worth keeping in mind that when we think in terms of just 2024, 913 people died of overdoses of fentanyl in Missouri. Do we need then to have 900 executions? We've executed 102 people since 1989. And, the message that's being sent out is that life is not so sacred. We will take your life. So I guess the last thing I'll point out is, what is the next logical step then? Do we begin to look at the reality that 3,500 people every year die of alcohol-related illnesses or abuse? So do we need to hold accountable people to deliver beer and alcohol to bars? Do we need to hold Anheuser-Busch responsible? So anyway, I think we need to think about trying to figure out other ways to deal with these problems. Alcohol and drug abuse.
Thank you for your testimony.
People should be available to get
any questions for the witness?
Thank you.
Seeing none. Thank you very much for your testimony. Is there anyone else here to testify in favor of Senate Bill 1392? Anyone else in opposition? Anyone here for informational purposes only? Then I will go ahead and turn this back over to the chair, but that concludes the hearing on Senate Bill 1392.
We're going to stand at ease until we can get one more member in here for the executive sessions on several bills. Now, as have we are in executive session. I now move that we bring for the committee Senate Bill 969 by Senator Fitzwater that we heard several weeks ago. Do I have a second? Having a second, we are now on Senate Bill 969. I now move that we vote Senate Bill 969 out of committee do pass. Do I have any discussion on the bill that was in regard to sexual offenders on school properties registering as a Tier 3 sexual offender who is a parent, legal guardian, or custodian of a student? Hearing none. Mr. Secretary, call the roll.
You have to make a motion.
I make a motion. There we go. There we have a second. Senator Schnelting. Mr. Secretary, call the roll.
Senators Schroer.
Aye.
Gregory 15. Brown 26. Berger. May. Roberts. Schnelting.
4-0. By your vote of 4-0, you have passed Senate Bill 969 out of committee. I now move that we bring up Senate Bill 1008 by Senator Berger. Do I have a second? Having a second, we are now on Senate Bill 1008. I now move that we vote do pass Senate Bill 1008 out of committee. This was Senate Bill, or the Senator Berger's legislation on authorizing the Attorney General to appoint commissioned and non-commissioned investigators. Is there any discussion? Seeing none, I now move that we vote do pass Senate Bill 1008 out of committee. Do I have a second? Having a second, Mr. Secretary, call the roll.
Senators Schroer.
Aye.
Gregory 15. Brown 26. Berger. May. Roberts. Schnelting. 4-0.
By your vote 4-0, you have voted do pass Senate Bill 1008 out of committee. I now move that we bring Senate Bill 996 before the committee. This is Senator Gregory's bill on modifying workers' compensation that we heard last week. Do I have a second? Having a second, we are now on Senate Bill 996. This was Senator Gregory's bill that we just heard last week on workers' compensation and complaints on ALJs and clarifying that process. Is there any discussion on Senate Bill 996? Saying none, I now move that we vote do pass Senate Bill 996 out of committee. Do I have a second? Having a second, Mr. Secretary, please call the roll.
Senators Schroer.
Aye.
Gregory 15. Brown 26. Berger. May. Roberts. Schnelting. 4-0.
By your vote of 4-0, you have passed Senate Bill 996. I now move that we bring up before the committee Senate Bill 1311 that I had last week on the amending the Supreme Court rules on continuing legal education. Senate Bill 1311. Do I have a second? Having a second, we're now on Senate Bill 1311. Is there any discussion on modifying the Supreme Court rule? This is the same bill that we passed out of this committee last year, Senate Bill 506. Any discussion? Seeing none. Do I have a second to, there's a second to vote do pass Senate Bill 1311. Mr. Secretary, please call the roll.
Senators Schroer.
Aye.
Gregory 15. Brown 26. Berger. May. Roberts. Schnelting. 3-1.
By your vote of 3-1, you have voted do pass Senate Bill 1311 out of committee. I now move that we bring Senate Bill 1393 before the committee. Do I have a second? Having a second, we are now on Senate Bill 1393. This is increasing the number of circuit and associate circuit judges in the 11th Judicial Circuit in St. Charles County. And I know Senator May, yesterday you indicated that I am the senator from St. Charles County. And we have another senator from St. Charles County here as well. So is there any discussion on Senate Bill 1393? Seeing none, I now move that we vote do pass Senate Bill 1393 out of committee. Do I have a second? Having a second, Mr. Secretary, please call the roll.
Senators Schroer.
Aye.
Gregory 15. Brown 26. Berger. May. Roberts. Schnelting. 4-0.
By vote of 4-0, you have voted do pass Senate Bill 1393 out of committee. And we just heard this bill, Senate Joint Resolution 93. This is one of the two bills that we heard. We're not going to exact the second one, but Senate Joint Resolution we have heard for several years. I now move that we bring Senate Joint Resolution 93 before the committee to vote do pass. Do I have a second?
Well, you have to bring it up. Second.
Having a second, we are on Senate Joint Resolution 93. Is there any discussion on voting this do pass? Seeing none, I now move again that we vote do pass Senate Joint Resolution 93 out of the committee. Do I have a second? Having a second, Mr. Secretary, call the roll.
Senators Schroer.
Aye.
Gregory 15. Brown 26. Berger.
Do you identify as two folks? I heard that. Okay, never mind.
May. Roberts. Schnelting. 4-0.
By a vote of 4-0, with Senator Brown leaving his yes by a vote of 5-0, Senate Joint Resolution 93 has been voted out of committee. Hearing no further business before the committee, I now move that we adjourn. Do I have a second? Second. We are now adjourned. Good work, Senator Hudson.
Thank you. And I just want to confirm, so 2 yes for all.